Good evening, ladies and gentlemen. Thank you for joining us for the second of the Defence and Security Circle's fireside chats. Tonight, we've got two experts who are going to help us understand the relationship between social media and the intelligence agencies, the intelligence community. But importantly, there are more than 40 people involved, both on Zoom and in the Lloyd Room. This is an event that brings people together who are interested in defence and security issues that are contemporary and also issues that are coming over the horizon, the new challenges. It gives me great pleasure to invite Dan Cope to take the lead tonight and interview Glen Hymers, our special guest, and I'm sure you'll be delighted. There will be a Q&A session afterwards, both from our in-person audience and from our Zoom audience. So please raise your hand, use the chat function to advise us on Zoom, and stand at the microphone ready to ask the question. At the end of the evening, which will end by 10 to 7, we will have a vote of thanks and we will advise you of our next event, which will be in the January of next year. All the very best. Enjoy.
Good evening, and thank you for joining us for our talk in relation to Max Schrems 2. My name is Dan Cope. I have worked in the data management space, specialising in data privacy for the last 15 years. I currently serve as the Senior Manager leading data privacy, ethics, model governance for HSBC across our wholesale branch of operations across 149 countries, along with serving in a number of other capacities. I will now introduce Glen, our most exalted speaker. Do you want to introduce yourself?
I shall indeed. Thank you very much, Dan. My name is Glen Hymers. I am currently the Global Chief Information Security Officer and Head of Data Protection for Save the Children International, a branch of the Save the Children Association charities. My background in the charitable sector, I've worked in the charitable sector now for 8 years almost. Previously, I was at Prince's Trust as their Chief Security Officer, working at that charity. And then prior to that, I was a member of MSSP. Prior to that, I was in the military for 15 years, where I served within the Royal Air Force Police in the counterintelligence branch of that service, and I currently still serve in that service as a reservist now that I've come out the other side. So yeah, interesting times for me over the last year. Was recently mobilised under Rock Rescript to do some work with that for COVID-19 response. So yeah, it's been an interesting year. It's been an interesting year for me. But thank you very much for asking me to come and talk about Schrems 2. I profess, whilst I am the head of data protection, I'm no longer a DPO, so I'm a bit more far removed from this as I would have been previously, but it's been an interesting journey.
Definitely. For those to bring a little bit of clarity in relation to Schrems 2, Schrems 2 was a case brought by Maximilian Schrems, an Australian privacy activist. 2015 originally?
Yeah, originally.
First time. For a action of how Facebook was sharing data with many parties and leveraging the processing basis of national security, which, when you look at it in relation to where it's being sent to, for example, with the US, and they're using the basis of national security as their basis of processing, it is rather self-explanatory of why would you send everyone's data, not just the US, for the basis. So on the back of that, the European Court of Justice invalidated previously Safe Harbour, which was Schrems 1. Maximilian Schrems then brought a second case in relation to Privacy Shield, which was the updated version from Safe Harbour, which was thusly invalidated as well. So we have now seen the adequacy and processing activities of many lawful bases being invalidated with potential risk for standard contractual clauses, known as SCCs as well, as part of that. We have a number of questions, as alluded to by Mr. Hymer, and we will obviously do get to your questions. So please do ask your questions, and we will answer them as we can towards the end. So, Glenn, the European Data Protection Act, GDPR, was adopted ultimately to serve a dual purpose of facilitating free flows of personal data with the European Union, whilst preventing and preserving the fundamental rights of individuals and whilst preventing misuse of fundamental freedoms. In particular, the right of protection of the personal data. In the recent judgment of Schrems II from the European Court of Justice, minded us that protection granted to personal data is across its entirety of transfer, not just at the time of collection or sending. And the protection must travel with the data wherever it goes. So with that being said, and that rather groundbreaking aspect, which has really transformed some of the practices, how has the industry been shaped due to the decision of the invalidation of Privacy Shield?
So how has it been shaped? I would say at the moment it's been shaped by lots of people running around panicking, trying to figure out how they're going to continue doing what they were doing before. I think that's the first point. The second point is how is it going to shape, rather than how has it shaped. So this is a relatively recent declaration by the European Court. The final statement came out in the summer of this year.
10th of November.
But that was the final adjudication point. But and then the European Data Protection Board have since issued further guidance around what that means. But I think the biggest thing that it's going to shape for us going forward is regarding the localization of data. At the moment, a lot of organisations are relying on, or were relying on, Privacy Shield to transfer that data with little or no hindrance, because it was basically a self-administered set of rules that was covered by an ombudsman in the States. And it was literally made life a lot easier.
And I think that was the key challenge, in the sense that the reason for Privacy Shield's invalidation was ultimately a contract is only as good as the controls and mechanisms you have around it.
Exactly that. And then if you rely on standard contract clauses, which is what everybody is looking to do now, the new guidance from the European Data Protection Board kind of further invalidates that further, because it's implying now that it is the responsibility of the individual sending the data to ensure that the standard contract clauses are robust enough to stand scrutiny in that country. So, for example, if you're sending data to the United States of America, you have a requirement to make sure that the organisation that you're sending that data to has written into contracts that you will robustly stand up to defend the rights of the individuals who that data is that you're transferring. Now, hopefully, fingers crossed, with the change of administration in the States, this will be easier, because it'll be a much more liberal environment. It won't be as draconian as it was previously. And the appetite for the incoming administration's relationship with the European Union should hopefully smooth this out a little bit more. They are going to have to work together to come together with some sort of arrangement about how this is going to work. I mean, if you read the articles in the press, the initial outcome from this was, are Facebook going to have to carve off its European activities? I mean, it's all well and good. Facebook do have an office in Dublin, but at the moment their model is set that all of their data returns back to the United States of America. It is centralised and it returns. So what does that look like? And this, when we're getting further into the cloud environment, and everybody is doing it, COVID-19 has expedited this journey much, much quicker than it would have done. Everybody was going to cloud, but I think this journey has been expedited much faster. And then you've now got issues where organisations are not really concentrating on where their data is going, and how that data is being transferred around the world. And this impacts that in a big way.
And I think that's where the judgment from the European Court of Justice really highlights key aspects, really, from GDPR that we knew. So I don't think it's honestly telling us anything new, just actually giving precedence, and I think ultimately giving us all a slap in the sense of, You need to ensure you're following the rules.
I think you're right. I think it is an element of a legal reminder and a quick slap from the court as to say these are those rules. But Maximilian Schrem's view on this is that it should be being used properly. What it shouldn't be being able to do is go to a country where they have an overriding piece of legislation nationally which says, oh, we're the intelligence services or we're a police force. We want that data. You will provide us that data. And then what the court says is it's fine. They can have that rule, but what you must have in your standard contract clauses is that organisation that you're working with will robustly defend your position. They will robustly say, no, you're not having it. It's not ours. We've transferred it here for whatever reason, but it's not our data. It's still European citizens' data. So therefore, the rules and regulations that are afforded to that by the benefit of GDPR is the rules and regulations that we must.
I think that's the key thing also really being reminded here is personal data. Is that the key word is at the beginning, it's personal.
Yes, it's data.
It's a bit like, if I may use an analogy, is if you're house sitting, you are unlikely to, hopefully, ransack the property if you are told to look after it in a certain way.
Yeah, exactly.
And so it's the same with personal data. It's not something you own. You are giving a custodian of that data.
And that is something that I say quite regularly at work. And if I'm out talking to people, if you're not happy with how that data is being used, if it was your data and you were not happy with how that data is being transferred or being used, then do something about it. It's not our data. No matter what we think, and no matter what the Amazons or what the Googles, other major global conglomerates are available, but they should be looking after that data because they are the custodian of it. They are not the owner of that data.
Definitely. And I think for those attending today, I think if anyone takes anything away from this talk is really understanding that as a individual, you do have a lot of fundamental rights and your data is, as clearly set out by the courts, important to be managed in an appropriate and safe way, rather than just having simply a contract of processing to say, yes, we agree, we'll do the following. You must ensure robust controls, as referred to by Glenn. You must ensure monitoring, oversight. Just simply writing it in a contract and thinking job done is no longer, and really to do from the beginning was never sufficient to start with. But I think if we're being brutally honest as professionals, what's taking place?
I mean, to be honest with you, there is an element of this as well, where GDPR, yes, everybody goes, GDPR is brilliant, but there are elements in GDPR that are really, really vague. Thou shalt do security by design. Define appropriate. And it doesn't do it. It just says you will do security by design. You will do data privacy by design.
This is why lawyers get paid a fortune.
Exactly. Exactly. And whereas us operational people have to muddy our way through it. So I think there's an element of clarification.
Definitely.
There's an element of clarification in Schrems where it says you need to have robust technical organisational measures in place to make sure that you're doing what you need to do and to validate that transfer rather than just going, oh, we'll just send it, it's fine.
Definitely. So since Privacy Shield is in place, does this have any consequences to how we manage the impact of data moving forward? Now it's been invalidated and SCCs are being threatened, which are obviously standard contractual clauses, known as also, you may refer to them as those that are studying law or those that are from a law background, known as montage clauses as well. What does it really mean? How are we actually as professionals expected to adapt? What has it done? Has it thrown the cat amongst the pigeons?
Yes and no. You'll find this, I do this a lot. I sit on the fence quite a bit. I play devil's advocate quite a lot. It does throw the cat amongst the pigeons because it's creating an awful lot more work. What it doesn't do, currently, the EPDB's, the European Data Protection Board's statement does not invalidate SCCs. What it does is it makes SCCs need to be more robust. So what you couldn't get away with doing, and I tell you what, it's actually had an added bonus because the European Union has now had to actually update their SCCs, because that did make me chuckle when GDPR came out and we were still all making SCCs in line with the previous directive as opposed to the regulation. And that's only just changed this year.
But definitely.
And it had to, because they knew Schrems was coming. And what it has said is you can't just cut and paste those clauses now. What you need to do is you need to make sure that you are making those clauses specific for your actual data transfer. Rather than just shoving it in and going, that's fine, it's got an SEC in it, we're done, let's move on. It now says, no, you've got to analyse it. You must do a risk assessment around this. You must make sure that it's robust enough, that it will stand scrutiny. So whilst those that are technically, the Privacy Shield things are now technically unlawful under GDPR, what we need to do is the European Union and the US will have to get into a room somewhere and discuss how this is going to happen. And I think what you'll find is, and it was an interesting comment that I heard recently, which is you'll probably find that these will now be bundled up inside trade agreements.
True, yeah.
Because at the end of the day, trade is key.
Money rules the world.
Well, yeah, but trade especially, because it's not just necessarily about money, but trade is king. And to get trade to work, you need to transfer data.
Well, that's where really the first principle, and I'd encourage anyone that's interested in this topic, do take the time to read the EDPB. Sorry, it's actually quite a hard acronym to say. It makes you want to change your vowels slightly. The European Data Protection Board. The first fundamental step is know your transfers. Mapping all transfers of personal data can be, and it also actually says it can be difficult. It understands that, but it doesn't mean just because it's difficult doesn't mean you shouldn't do it.
No, exactly.
And that's the key thing, I think, for any organisation. Just because it may be easier to ingest that little bit of extra data, just because it's easier to keep the date of birth in rather than removing it, just because it's easier to keep the year in when you only need the day and month.
And that's very valid, and that's very true. You find most organisations will go, oh, well, it's easier just to maintain a database on everything. Why should I edit that? Why should I look to whittle that down to what I actually need? Whereas a lot of organisations, especially things like the bigger ones, will be like, yeah, but that might come in useful. I might need that at some other point. But the problem with that
might be able to use that for marketing.
But the problem with that is you get yourself in a position where you end up with a load of data that if that gets breached, questions are asked as to why you still have that data. Where's your legal basis for holding that? What are you relying on legitimate interest? Have you got consent of the individual? And the problem with this is, well, not the problem, but a fundamental issue with data protection in general is that what you find is people don't read their terms and conditions. I mean, last time you updated your iPhone, who waded through the 520 pages of terms and conditions that Apple threw at you? Yes, no one. Tick yes, thanks very much. And it's the same principle. Yeah, you just want the update, and you can't get the update unless you say yes to that. And it's the same.
The update so I can access my work emails.
Exactly, and it's the same principle when you go online and you shop. And the whole cookies debacle. And that's a whole different thing. Well, let's not go down that route because that's a whole different.
I really do encourage. There is an app that you can use called CookieBot. If you want to see whether your company is compliant, type their web address into CookieBot, which is a free app on Google. You can type it in, it will email you a response and it will tell you exactly whether your company's compliant or not. Yeah,
that's a whole different thing. I'd like to get to a world where we don't actually have cookies, but that's never going to happen because how do you do digital marketing at the other end of that? And I don't want to make anybody unemployed, but anyway. But to your point about what's the consequences for the future and what are the impacts, predominantly it's around due diligence.
Definitely.
So we are all, as data protection specialists and professionals, and those that have an interest in this, will have to do their diligence on the organisations where they're sending it. And this kind of then ties in with what's going to happen through the year in 2021. So there's a lot of countries out there, Brazil, for example, Indonesia, Singapore, India as well. India are almost about ready to issue their new data protection legislation, who are taking GDPR-based principle approaches. And bizarrely, China China is taking the GDPR, but
China really adapting it.
Yeah, well, they're making it a lot more robotic. They have an awesome piece of legislation. Let's take that and we'll put that in our legislation. But they're businessifying it rather than the
very technical term there.
Yeah, businessifying it. Yeah, I made that right up there then. But the European GDPR came about as a result of the struggle of what we went through as a society in the 20th century and bits previous. So it comes in to that fundamental rights of the human, fundamental rights of the individual, all of those good things that we have over the last 100 and so years fundamentally learned and become comfortable with. Whereas places like China is like, well, actually, we know if we want to transfer data from there to there, we've got to have something that looks good.
Well, in all honesty, we've seen it time and time again. Saudi Arabia have obviously implemented a new law. We've seen the California Consumer Data Protection Act.
Yeah.
Although, with credit to them, there are minor tweaks. Yeah. In the sense, instead of it being a gold pen, it's a brass pen. It's still a pen.
It's still a pen.
They've just taken the same pen and just changed the name on it.
Yeah.
There are some fundamental changes. And I must say, one aspect with Schrems 2 is, actually now, it's going to make it far more costly, ultimately, to ensure you know your data, know the mechanisms that you are operating under, know the fundamental verification of tools that you're relying on, the lawful practice, and a number of other things. They are just to name 3 of the fundamental steps from the recent guidance. So do you feel Schrems 2 has had an impact in a positive way or a negative way? And has this improved or negatively impacted consumers?
It's both. There's the easy answer to that one. I feel sorry. I'm sorry that I keep doing the sitting on the fence thing, don't I? But it is both. And it would depend which side of the house you sit in at the moment. I can tell you right now who is seeing it as a negative impact, and that would be the Irish Data Protection Commissioner. And the reason the Irish Data Protection Commissioner is seeing this as a negative impact is because they've just lost almost, if not more than a tenth of their annual operating budget. And the reason they've lost it is because the European Court turned around and went, by the way, though you were a co-plaintiff with Maximilian Schrems, you're going to pay all of Maximilian's costs. So they're looking at a bill of nearly €5 million. And that's when you incorporate all of the previous costs that were going through. Because the reason Maximilian Schrems took them to court was because he originally went to the Irish Data Protection Commissioner, because that's where Facebook are registered in the European Union, and said, I fundamentally disagree with how this is happening. The Data Protection Commissioner went, okay, thanks, see you later. Didn't really do anything with it, sat on it for a long time. And I get they knew they had to do something about it, but it was only when Maximilian turned around and went, right, I'm taking them to court, that they sat up and listened. And I get that, because how does someone with a very small budget and a very small team take on an organisation like Facebook?
True. But still no excuse. And I think that would be a lesson, I think, here also, in the sense of regulators don't always get it right.
No, they don't, not always.
And you have, and this is where the fundamental rules are now shifted, you must have remedies available immediately, even before you begin the transfer, to be able to implement, not thinking about the remedies after an incident's happened. You must be able to say, right, turn the switch if something has happened. No, exactly. Because you've got it in place.
But to the average person on the street, there will probably be fundamentally no difference. They will not see any difference whatsoever as a basis of Schrems. And the reason I say that is these processes and these transfers will still take place. Those that will see a difference are those working in the data protection environment. And that difference, I mean, for the individual, there's a positive impact, because if I would say I work for, let's use Facebook again. I work for Facebook and we're transferring the data. What I now need to do here in the UK is carry out a very, very intensive due diligence process to make sure that that data will be protected to the best of the abilities in regards to the regulation. So the protections are going, hopefully, would be there. So the individual themselves they won't notice any difference. The data transfers will still take place. Who will notice a difference, like I say, is individuals like myself who work in the DP space, where we are doing a lot more work and relying on either SCCs or BCRs, so finding corporate rules for those major global organisations, because that's another avenue for transfer. And it's a hall of mirrors. The data that global organisations still need that data to function. If they can't have it, then they won't function. Interestingly, I don't know whether those that are interested in this space, the EU has just recently published a paper, or was it the EU or the Council? I can't remember which, but they've just recently published a paper around the new EU data framework. So what they're looking to do is set up a tools and technologies within Europe to allow easier data reuse. So you're looking at that commencement of data islands and the localization of data, because their view is that if we can transfer that data around, that data is much easier to use and more free, then that works. But that's because it's within the confines of GDPR. If you take that away and you then have to do this globally, how does that work?
Definitely.
So are we looking at a view that in the future, we're either looking at mass data localization and data islands, or are we looking at potentially going forward something like a global accord on how data is managed globally? So that would then allow massive organizations which operate on a global level to transfer that data around easily.
Definitely. I think it is an interesting one. For those that aren't aware, what is the difference between a binding corporate rule and an SCC?
So an SCC is a standard contract clause which you would throw into a contract for either suppliers, vendors, all of that kind of stuff. A binding corporate rule is where you get a number of organisations. So let's take Save the Children. So Save the Children International is a federated environment. We have 28 members and my part of the organisation, and we all operate under an organisation, an umbrella organisation called Save the Children Association. Now, each one of us are all separate legal entities, but we all work to the same theme. So what we can do is we can say, well, we're all working to the same theme. We are visually out to the world a global organisation. So what we will do is we will set a set of rules across all of our organisations, which we will all sign up to and run with. HSBC, let's take your organisation. HSBC will do something very similar in its space. So it's Singapore arm, it's various ones around the world. What you will then do is go, right, this is how we will all handle data together. And that is a corporate rule. What you have to do is you compile those corporate rules, then you take that to your regulator, and the regulator then agrees those rules with you. They say, yes, we're happy with that, or we're not happy with that, we'll tweak that, do that. Whereas a standard contract clause is a clause developed by the European Union, which you just go to a website, cut, paste, drop it into an email, drop it into your contract.
And obviously, one aspect that many may not be aware why large organisations are split by legal entities, you can't have a contract with yourself. So hence why you are split into legal entities.
Exactly.
Otherwise, it's not a valid contract.
Yeah, it's very true.
So what controls and formal procedure steps should an organisation implement to meet the latest guidance from the 10th of November?
Without getting all principally on everybody, and so I will just throw out one, which is Article 46. And that is, you must define whether the transfer of the data is legal in the first place.
Definitely.
If you don't have that legal basis for transfer, then you shouldn't be doing it. But then after that, they need to be making sure that they do their due diligence. Are you looking at how that data transfer? How is the organisation that you're transferring it to going to behave with it? What mechanisms are you using? Are you going to do strong technical measures, for example, like encryption? Now, there are all sorts of other rules around encryption, in as much as if you do encrypt it, the keys must remain in the European Union. They can't be transferred outside of the European Union, they must stay here. Or they must be with, I say that, they could also be in a country that's got adequacy. Very true. But that's a whole different ballpark, because there's only 12 of those in the world. And so,
they're always constantly shifting.
Yeah, they're constantly moving around, yeah. But they need to make sure that the standard contract clauses that they are using or are going to use are strong enough. I think you could refer to it as SEC plus, for example. And making sure that there's within those SECs you outline the obligations, that the technical measures, the transparency, but most importantly, and this comes out of the European Data Protection Board's advice recently, which is to make sure there is a clause with an obligation to review and challenge the legality of any compelled disclosure order.
Definitely.
So if an organisation, law enforcement or otherwise, comes in and says, you will give me that data, you must have that ability to turn around and go, no, I can't, it says here. Definitely. And we will go to court.
And ultimately, there's, for the benefit of everyone, it's 6 steps. It's not necessarily as difficult. It's not really a difficult ask. You don't need a lawyer to interpret any of this. A lot of this is actually, most of data privacy is common sense. It's really data privacy in general is know your data, know what it's being used for, why you have it. But in terms of data transfers, which is the sharing aspect, which we take the assumption you've already conducted your assessment and mitigants in relation to whether you should have that data in the first place, is know your transfer, identify the transfer tool you're relying on, assess whether the Article 46, as you referred to, GDPR tools you're relying on, is effective in light of all circumstances of the transfer. So ideally, where you're sending it to, you may need to make tweaks. You know, there is going to be different controls between sending it to Saudi Arabia than there is to Russia. Both not great options, but from a privacy law perspective, but there we are. It's then also adopt summary measures, so they're your remedies. Step 5 is your procedural steps if you have identified effective supplementary measures, and step 6, which is your reevaluate and at appropriate intervals being your monitoring. So we're now going to progress to our Q&A aspect. So I do encourage you to try and ask whatever questions you do have in. We will be going to our first question. So I will hand over to our room, our David Lloyd George room, for the first question, please. If I could ask you to state your name and what the question is, please. We cannot hear you, sir.
The microphone's not on.
We cannot hear you. You are muted on Zoom.
It's not muted.
Is this me?
I can hear you, Shaun.
We can hear you, Shaun. You are now...
You've just muted yourself.
Go to Shaun first.
Yeah,
Of course. Wonderful. Shaun, we'll go to you for the first question, please. I believe your first question relates to an alternative to the David Lloyd.
No.
In the room, please. So, do you want to ask your first question? What's your first question, Shaun, please?
This was, do you believe most organizations are actually fully compliant with GDPR, the actual policies? Because people say, yeah, we're GDPR compliant, but really? And would it stand up if there was some kind of breach, or they were pulled into some kind of dispute and the legal counsel said to them, you know, would they be legally defensible?
So do I think most organisations are legally compliant? I would suggest if they're not compliant, they're on some way to being. Now that would depend on the size of the organisation. GDPR, despite the fact that it was released long before it came into force in the UK, was a last-minute .com rush. Every man and their dog rushed at this in 2018 to get it out, even though, when did it come out?
2018.
No, it came to law in 2018, but it was released from the European Union in 2016. So we had a very long fuse time to get there. So I would suggest that some organisations are a lot further down the line than others. Now, would it be legally stand up in court? Now, that's a whole different ballgame. I think the biggest piece of advice I can give, or the biggest answer to that question is if you are on that project and you are on that journey, and they have, it's like a maths exam, as long as you can show you're working out and you have some sort of basis for showing that you're doing data protection over and above what they were doing previously. I mean, the big problem with that is there's an awful lot of organisations out there that said they did data protection out in 1998, and they didn't, which meant their delta gap between where they needed to be and where they, also where they were and where they needed to be, was huge.
And I think that's the key thing there is also, if you did the Data Protection Act of 1998, actually there wasn't that much work between GDPR. Yeah. It's when you didn't, when there was a bucket of work.
Yeah, and the ICO as the regulator recognised that. And their view on life is that this is an ongoing project. This is not something that will ever stop. This is something that will go on and on and on, and is a long life thing. What you shouldn't do is tick all of your boxes that you think you tick, put it in a drawer, shut the door, and walk away.
Definitely.
What you should be doing is looking at it and reviewing it as you go. Whether it stands up in court, we don't know, not yet, because no one's challenged anything that the ICO have yet to regulate on. I mean, the BA challenged their fine, but they didn't challenge the findings of the investigation.
Definitely. And I think the key bit to that is ultimately, if it is brought to court, it will be a specific aspect of the law, not necessarily the law requirement. And GDPR itself has obviously really just enhanced the aspects that we already had. So ultimately, I think the key thing to remember is if you hear any organisation, vendor or an organisation that says they can make you 100% GDPR compliant, we know one particular that begins with one, that say that. It is absolutely not true. You can never, no matter whether you had an army of data privacy lawyers and an army of data protection officers as per Article 39, you are never going to be 100% data privacy compliant, because you can't be. There is always going to be an adaptation, and the landscape is always moving. This is why it is actually a very interesting space to work in.
I mean, impacts of things like trends and stuff like that moves and matures the area. But what it does is it also then kicks further problems into the long grass down the line. It's a living, breathing area of work. It's not something that's going to just come to a halt. But as long as, like I say, as long as you can show you're working out, if you were ever to have a breach and the ICO does come knocking, they might disagree with your theories and the way that
it's unlikely you'll get regulatory action as long as you can prove you have taken proportionate and reasonable steps. We're now going to move to the DLG room. Please, could you give your name and then your question, please?
Still can't hear you.
We can't hear you, sorry. I'm afraid we can't hear you, sir.
I think maybe changed. Ah.
Hello, can you hear now?
Here we are. Thank you. Technology works.
A round of applause we need for that. My name is Humphrey Hawks. I've got a question about HSBC, counterintelligence and data. And around a couple of years ago when GDPR came in, I was in a conversation with HSBC Bank, and they asked if I minded my data being transferred, and they hadn't actually come up with this before because of GDPR. I said, yes, I did. And then it turns out that all the data of our bank accounts, our gas bills, our telephone bills, every month are sent to 3 credit reference agencies: TransUnion, Experian, and Equinox. Equinox is it called. I said that I didn't want this to happen. HSBC said then I would have to close my accounts. This went to the FCA and the Data Commission, and they said this was perfectly acceptable and we could do nothing about our data being in the hands of these 2 companies. 2 of these are foreign owned. I then talked to contacts in the various security agencies, and they said it's a very good, useful tool for them because they have a mechanism to find out, for example, that I have had a glass of wine here at the National Liberal Club because I put it on my credit card. I would like your view, I'm sure it's legal, on this. How does it, on this all this stuff about data that we talk about and security, how does it sit with that? How does it sit with our values? And is it right that a private company hiring people on 0 hours contracts knows that I had a glass of wine at the National Liberal Club?
Of course, thank you, Alan, for the question. And although I work for HSBC, by no means can I speak on behalf of them. By every statement that I make here is my opinion and by no means an affiliation or representation of any organisation I represent, whether that be my employer, the NLC, or a number of the other charities where I sit in the trusteeship. However, where data is transferred, obviously we have a system and a practice of ensuring a level of credit risk is maintained and to ensure that reasonable lending and reasonable management to that is afforded. Thusly, there has to be a way to judge that, and it has to be judged fairly rather than each bank or each business making their own mind up to a degree to that aspect. Thusly, the credit reference agencies do leverage quite often aspects in relation to the FCA compliance requirements. And so there are a number of lawful bases it bases on. Whether, I'm afraid I can't answer it explicitly in relation to where the agencies are based, whether that would be in proportion or not. But it's a very interesting question. I must say, not one I have thought about myself.
It's a very valid point. I mean, to Humphrey's point around, is it ethically right? In the good old days, before computers, if you wanted a loan, you went to your bank manager, and your bank manager interviewed you, and your bank manager made a decision on you. That was then placed in a file and placed in a dusty drawer somewhere. So the data was still collected, but it stayed locally. I think to Humphrey's point, what we are getting to now is a society where the data is so fluid and it's so moved about the world, you actively lose track of it. And you don't know what other people are potentially doing with that data. To the point about the 0 hours contracts, yes, that's something that I can't attest to, but it's something that, for me, working in an IT security and working in the data protection space, the organisation should be putting, if your data is being transferred to that organisation, should be putting all rules and regulations and everything that it can put in place to make sure those individuals who are accessing that data or seeing that data are, one, who they say they are, two, that they are securely vetted and they are not likely to, because the biggest threat to this is the insider threat. Where's that data going to go?
Indeed. And I must say one of the main threats for any organisation is internal. And this is where I know, for example, with HSB specifically, they have a very robust vetting process. I know for me to join, it took several weeks nearly, and I know for others it can take months, where they go through a intensive process of checking and vetting and aspects like that. And ultimately, from an ethics perspective, in terms of 0 hour contracts, I think they work for some, they don't work for all. Some like the flexibility and some don't. There is a big debate where on both sides of that. Some believe it's unfair to not set a minimum expectation so that they can obviously thusly claim when needed, because that is what, for example, some of the support from COVID from the Chancellor has been based on your contract hours. Those that obviously do not have that have obviously been taking their average hours. Now that could obviously be a lot less or a lot more. Obviously, it depends on the individual situation. So I think there's an argument for both. My personal view, 0 hour contracts, I think, have a place, but I think they have to be used very sparingly and in the right situations and for the right people. It shouldn't just be a general tool. If a contract with hours is better suited to a person, I believe the personal aspect of the nature and that relationship should be considered in the first and primary instance.
I mean, yeah, so to the point about the 0 hour contract, and then I think we'll bring this one to a close and go to the next question. But I think For an organisation such as Experian or other credit referencing agencies are available, I think 0-hour contracts, personally for me, is not something that we potentially should be looking. They should be potentially looking to use, because of the work that they do is a little bit more in depth and a lot more integral. So yeah, I think 0-hour contracts are good for for certain parts of certain sectors, but not necessarily should be used in something along this line. And I'm inclined to agree with Humphrey on that, to be fair. But there we go.
I must say, it's a very interesting, and I must say, thank you for the question. It's not one I've debated in my own mind.
No, I haven't thought that through either. I didn't realise that people like Experian were using 0-hour contracts. But
no, that would be something I've looked at. Yeah. But I would, and this is just general advice, I would encourage you to write to the DPO for the corresponding countries and organisations. You have a right to understand how that your data specifically that pertains to you. Obviously, you can't ask for somebody else's, but you can ask, how is my data managed and where is it sent, please? And that can obviously be actioned through a subject access request. So where you have that requirement or ask, then please do so. And I would encourage all to look at their data and challenge organisations when appropriate.
The other aspect to that is you also have the right to request that your data is not covered off in an automated process. So if your data, if you think you're being overly penalised for whatever reason, then you can go back to the organisation that processed your data in the first instance and say, I would like a human to look at it. And they have to do it. They have to do it under the GDPR.
Of course. However, as stated, obviously, we don't provide any speculation or judgment there in relation to either aspects, and nor do I make comment in relation to my organisation's practice, as I'm afraid I'm not informed necessarily on that specific aspect. However, if it is a concern with HSBC, do feel free to contact us via the customer service route, and they'll be able to assist. Moving on to the next question, to Robin Ashley, please.
Hello, I'm Councillor Robin Ashby from Newcastle upon Tyne. I rather think the last questioner was highlighting the abuse of power by the large people as against the small people. In theory, you could renegotiate your terms of access with Microsoft or one of the other software companies, but good luck with that one. And when the banks basically are almost monopolists, and it's take it or leave it, then the small people have no power whatsoever in all of this. And the fact that they can effectively push you out because you raise these sorts of questions is in fact extremely serious, because without the bank account, without your these computer accesses, you are basically non-persons. You just don't exist. But that was not the point of my original question. It was really to sympathise with the previous questioner. But obviously, a lot of us here are interested in data for political campaigning purposes. We're dealing with individuals, the voters, not businesses, and there's a huge disinterest amongst most of the public about rules and permissions and ticking boxes and all that sort of stuff. Now, the big stick of prosecution is waved in our direction, but when businesses have been taken to court, as far as I can see, the penalty seems to have been infinitesimal per individual address. So while there may be technical offences committed, how much at risk are political parties, or in the case of small businesses like the ones I'm associated with, who want to use the email addresses that they have to send out a list of recipes, or to send to students who occupy our premises, who are Chinese or Filipino or whatever, and yet I have to have a license in order just to hold a dozen or so names and addresses that are actually related to people's tenancy agreements. And it seems to me that in that case, this is just a way of the Information Commission of people raising money. And of course, I'm sitting on their database for them to demand the money from me.
So to the point about the use of the data, as long as you're using the data for the purpose that you've originally told the individual from which you collected the data that you're going to use that data for, then the legal basis for processing that data, the risk to that is minimalistic.
The key aspect there is obviously transparency. Yeah, telling the person exactly what it was for, and obviously ensuring that the person was for any purpose you may extend it to, if that's marketing, that they're aware that their data would be used in that way, and you've given them the option to say no where appropriate. Obviously, some aspects don't give you requirements or aspect to say no, for example, where it is regulatory, etc.
But in regards to the ICO using it as a big stick to raise funds, Elizabeth Denham has very, very clearly said that that is not the case. They don't keep those funds go back into the Treasury coffers. So yes, she might get an increase in budget in the following year, but that's not what they're there for. And the fines are proportionate to the size of the organisation. That is the whole point of GDPR. It's based on your global turnover rather than an indiscriminate amount of money. So, for example, when BA got its fine for its breach earlier on in the year, that fine looked massive, but that was because, to Councillor Robin Ashby's point, is it was around they were flagrantly not putting into practice what they should have put into practice to protect that data.
And they knowingly did so.
Yeah, and that's the point. So as long as, so the fines are proportionate per the organisation, and to the point about risk, as long as you're using the data for what that data is collected for in the first instance, then there should be no risk associated.
So as practical advice from it as a political party wanting to send information to a subject, provided you've taken that email address, you've taken the postal address, or whatever you've got, and you've said to the person before collection of that information, hey, by the way, Dan, are you okay with us using this in this way? Here's what we're going to do. That is obviously the sole purpose, ultimately, of the data privacy notice. So always encourage you to read your privacy policies to do that. So there are aspects that you can lean on. So, for example, where we use the basis of legitimate interest, and you're saying, I believe it was in the interest of the person for this to take place, and that it could have been reasonably construed that that would have been asserted at the point of collection, then obviously there is a debate. But also, to be clear, there are a lot of stringent controls. You have to complete a very detailed balance test where that is the case, if you're trying to use it for a slightly nuanced purpose, not necessarily a new purpose, but a nuanced purpose being the difference. Hopefully that answers your question. Moving on to Lana in the DLG room, please.
Hi, my name's Lance Roberts. Just really sort of interested on your sort of views and reflections on how we take a consistent approach on an international basis. So I'm sure you're all aware, many companies, organizations, they all go through changes over the course of their lifetime, mergers, acquisitions, bankruptcies, parts of the businesses, particularly intellectual property, or in this case, people's personal data. It can be perhaps fragmented, bundled up, sold off to different users, and that can be across different regions across the world, perhaps subject to different data security legislation and procedures. So it's really thinking about, well, when that data was originally created, stored, analysed, it then ultimately passes on through the course of its lifetime to somewhere else. And this might be more prevalent in more, virtual-based businesses where a business transaction or concern can easily then be bought by an overseas company. They're registered in a completely different region, subject to different legislation. If we're trying to, take a consistent approach and, effectively manage people's personal data, and how do we ensure that the end use, let's say, of that data still meets the original expectations? Is there some kind of clause on the sale of a business or the transfer of the data that it must be treated to the same level of data security?
Yes, is the easy answer to that one. So GDPR says data for European citizens, regardless of where they are in the world, regardless of whether they live in Europe or whether they live abroad or wherever, as long as they are a registered European citizen, their data must be protected in accordance with the GDPR.
So that actually refers to the extended scope of data privacy within GDPR, and for specifically also in relations to Transfers, obviously that refers to in relation to collection, but the same applies in terms of transfers as per the guidance from the European Data Protection Board on the 10th of November, so very recently, that protection must go with the data. It can't just be a stopgap. It can't just be at the one end or at the other end of the process. It must be in complete transit. So hopefully that answers your question. So moving over to Dr. Michael, and I'm afraid I might not get your last name correctly, McDonagh.
Yes, it's actually McDonagh. Thank you for a wonderful and interesting talk. Question for Glenn, really. In your opinion, has the introduction of GDPR assisted or hindered security professionals when they're dealing with the insider threat?
There's no actual easy answer to that one. So in my opinion, I think it has made life more difficult. So when you're coming to the insider threat piece, there is a whole more rules and regulations that we need to be affording to the actual individuals whose data that we're looking at. So with my other hat on, with my other world, it makes life a lot more complicated. We've got to jump through a lot more hoops to do what we need to be able to do. Luckily, if you're working for an agency or you're working for the government or a local authority, the GDPR makes expectations for that, and there are different rules and regulations around the processing of the data for that. If you're working in a business environment, then it makes it much more difficult, because how do you tell the individual that you're investigating why you're investigating them?
And also quite often you're actually not allowed to tell them you're investigating them. Because then obviously they will start, they'll
start extracting all of the data.
Extracting the data and enacting rights and,
exactly.
Perhaps doing the old-fashioned pull the file out and burn it.
I mean, in the old world, it was really easy. If you thought someone was a problem, then basically what you did is you started monitoring their use of your IT equipment to see whether they were doing anything nefarious and extracting anything. But these days, you've got a lot more hoops you've got to jump through to get to that point. That's a really good question.
Now to Ashby Doyle, please.
Hello, can you hear me?
We can, sir.
Thank you. My question is fairly simple. We all know that every piece of data, be it a Facebook post, a LinkedIn post, even an email that is sent in closed circuit, is an irreversible act. It's in cyberspace, it's going to stay there, even with deletion. So how much protection can we reasonably expect regarding the data that we no longer want to be in cyberspace or use whatsoever? Okay, so let's say I've put something on Facebook, I've deleted it, but someone is using it. How much protection can I reasonably expect against something like that? Thank you.
Interesting question. I suppose ultimately it does come down to aspects such as the right of a rager, or known as the right to be forgotten, where the organisation, it does depend on the data, but they have to, where the right is applicable, there are criteria to where it is not, remove that data where it is irretrievable. So quite often I do get asked the question in the sense, can we just keep a stub record so we can identify them down the line? Well, if it's still identifiable and you have no basis to hold it, the answer is no. It's very clear. But in terms of social media specifically, yes, you have the right to enact an erasure. They would still have to take all probable aspects to ensure the data is erased. However, if somebody's taken a screen grab or copied that, and you made it within the public domain and wasn't necessarily private or given any disclaimer, I think from not necessarily a privacy perspective, it's then more of a aspect in relations to common law in around, which regularly happens with obviously celebrities and obviously the aspects of Freedom of Press Act, etc., and would be more of a relations to the Copyright Act of 1988 rather than data privacy.
I think it's a very good question, and there's been a lot of people fall foul of it. All you've got to do is look at Twitter. There's a prime example of that. So you put your tweet out there, it gets seen, and then people remember that, and then 15 years later it comes back to haunt you when you get into public life or whatever. And we've seen many a celebrity and many a political individual fall foul of that. And that would then be taken up as a civil case as opposed to anything else predominantly, I would suggest, rather than, because once it's out there, as you say, it's out there. And if someone wants to use it for those nefarious reasons.
And I would say if they are using it in nefarious aspects, which is defamation or aspects in a relationship, it obviously, as ever within law, the nuances of the specifics are what counts. But obviously, there, as ever, there are legal remedies and you can take that action to the court. Well, I'm afraid that is our time for this evening. May I thank Glenn for his time, and I now pass over to Irina for our closing comments. Thank you so much.
Thank you very much. My name is Irina von Wiese. I am not only a former member of the European Parliament, I also worked for about 10 years as a competition lawyer for an international trade association. So I have actually seen both sides of this very difficult problem, the regulator side and the regulated side. And transfer of data is crucial in the context of international trade, but it's also more and more likely because of the sheer volume of data and the sophistication of the analysis of big data to infringe on all of our personal freedoms. Regulators are struggling with this. And I think what was mentioned here tonight and what I'm taking away is that what really is needed is a global accord on how data is managed globally. So in this spirit, I would like to extend my thanks also on behalf of the National Liberal Club to Dan and to Glen, who are actually sitting behind me. It's a bit odd because I have to look in this direction, but I would like to extend personally the thank you.
Thank you very much.
Next time, hopefully, we'll be able to have a more sociable context where I can look at you while I thank you. But for now, remains to be said, I thought it was a really engaging evening. And thank you to the audience for your very interesting questions. Good night.